I love the Supreme Court. I understand that my proclamation makes me a giant nerd, but it's true. If I were to mention facts about the Supreme Court to any of my friends or family members, they likely wouldn't know what the heck I'm talking about, so that's why I'm making this video. If you clicked on this, you likely have at least some interest in Supreme Court history, or American history at least, or you could just be a struggling college student like me, looking for a research topic for your stupid AP Gov class. Well, if that's the case, I got you. Although I love researching Supreme Court cases most of the time, there are also times where I read about cases and can't help but exude just feelings of anger, pessimism, and downright embarrassment. At their best, Supreme Court decisions can provide a guideline to democracy, ensure equality, and keep other branches of government in check. At their worst, these decisions can instill precedents of tyranny and racism, reshaping the values the United States was founded on in the first place. Some of these decisions harbored consequences that affected thousands, and in some cases, millions of Americans. Despite this post being a top 5 list, I just want to preface that this is not a rankings list, as I would feel wrong saying that some of these cases are worse than others due to just the sheer amount of people that were harmed as a result of each of these decisions. So, with all that being said, here are the top 5 worst Supreme Court decisions in American history. The first entry of this list is Dred Scott v. Sandford. Dred Scott v. Sandford, better known as simply the Dred Scott decision, is the most infamous Supreme Court decision in history. Many historians cite the Dred Scott decision as one of the catalysts that led directly to the American Civil War. The story of this case began in 1838. Dred Scott was a slave who was owned by a man named John Emerson. Emerson served in the United States military, and he frequently moved from state to state, always bringing Scott with him. Emerson and Scott moved from Missouri, a state where slavery was legal, to Illinois and eventually the Wisconsin Territory, where slavery was illegal. It was in the Wisconsin Territory where Scott fell in love with Harriet Robinson, a fellow slave, who he would go on to marry and have 2 children with. Emerson later moved back to Missouri, temporarily leaving the Scott family behind for a number of years as they were leased out to various Army officers. When Emerson moved back south, he fell in love with a woman named Eliza Irene Sandford, and the two would go on to marry. Shortly after marrying, Emerson ordered Scott and Robinson back to Missouri. On the Scott's trip down, Robinson gave birth to the couple's first child, somewhere in between the Wisconsin Territory and Illinois, although the official location is unknown. The whole point is, their child was born free. Despite the events, the Scotts moved back to the Emerson estate in Missouri. In 1843, John Emerson died, and his wife Irene inherited the estate. After John Emerson's death, Scott attempted to purchase his freedom from Irene, but she refused. Dred and Harriet Scott sought help from legal advisors and went on to file separate lawsuits against Irene in 1846. The reason why the Scotts could afford lawyers in the first place was actually because Dred Scott's previous slave owner gave the couple money to help pursue their freedom. It's pretty ironic. The Scotts sued based on 2 Missouri statutes. The first statute allowed for any person to sue for wrongful enslavement. The second statute said any enslaved person that was taken to a free territory was automatically free. Historians are unsure why the Scotts did not pursue their freedom back when they lived in Illinois or the Wisconsin Territory. The Scotts lost their respective cases in the St. Louis Circuit Court on a technicality, since they could not prove that they were Irene Emerson's slaves. However, their lawyers obtained a second trial for the couple that was delayed until 1850 due to a variety of circumstances. When the trial finally took place, the Scotts were able to prove that they were, in fact, Irene Emerson's slaves. The jury ruled in favor of the Scotts, and the family was given their freedom. Unfortunately, Emerson continued to push the issue. After being denied a retrial, Emerson appealed the case to the Missouri Supreme Court, and they ruled in favor of Emerson, saying that the Scotts were still slaves since they lived in Missouri. In 1853, Dred Scott filed another lawsuit, this time to the United States Circuit Court for the District of Missouri. Scott no longer sued Emerson, as her brother John Sandford now claimed he was Scott's slave owner. The federal court ruled in favor of Sandford in 1854, but Scott's lawyer, Roswell Field, appealed the case to the United States Supreme Court. The court heard oral arguments for this case in 1856. A worker actually misspelled Sandford in court records, so the case was officially named Dred Scott v. Sandford rather than Dred Scott v. Sandford. On March 6, 1857, the court announced that they had sided with Sanford in a 7-2 decision. Infamously, Chief Justice Robert Taney wrote the majority opinion in this case, saying that any person who came to the United States from Africa or were of African descent were not citizens, and argued that the Supreme Court should have never heard the case because the Scott family were not citizens. This decision caused one Associate Justice, Benjamin Robbins Curtis, to leave the court. The decision also proclaimed that the Missouri Compromise, a law that attempted to keep the balance between free and slave states, was unconstitutional, and that Congress had no right to pass legislation that would slow down the spread of slavery. This decision infuriated Northern abolitionists, leading to a stronger divide between the Northern and Southern states. The decision would finally be reversed after the Civil War with the ratification of the 13th, 14th, and 15th Amendments, as well as the passing of the Civil Rights Act of 1866. The Scots were freed just a few months after the decision was made, however. Emerson married a staunch abolitionist and a U.S. representative. After learning that Emerson owned the Scott family, the representative convinced her to sell the Scots to the Blau family, who previously owned them and actually gave them money to sue in the first place. The Blaus set the Scots free in May 1857. Dred Scott would go on to die just the next year. Coming in at the second entry of this list, we have Plessy v. Ferguson. The story of Plessy v. Ferguson began on a train in New Orleans, Louisiana in 1892. Around this time, segregation and Jim Crow laws ran roughshod throughout the southern United States. The plaintiff in this case, Homer Plessy, boarded a train and took his seat in a section designated for white people only. Although there are not any photographs of Plessy, historical accounts described him as a white man. Plessy was 1/8 black and 7/8 white. However, the train conductor knew Plessy was 1/8 black somehow. The conductor told Plessy to move to the colored section of the train, but he refused. Plessy would go on to be arrested shortly after by a police officer named Christopher Kane. However, this incident was a coordinated plan. Plessy was a member of a civil rights group named the Citizens Committee, who wanted to take the Separate Car Act, a law that enforced segregation on trains, to court. The detective and the railroad company were also in on the plan. Kane was hired by the Citizens Committee to arrest Plessy, and the railroad company hated the Separate Car Act because it meant that they had to spend more money on additional train cars. Plessy argued to the New Orleans District Court that the Separate Car Act violated his 13th and 14th Amendment rights. The judge, John Ferguson, who would later become the defendant in this case, disagreed, saying that the state had the right to regulate railroad companies that were within state boundaries. Plessy went on to appeal his case to the Louisiana Supreme Court, filing a lawsuit against Ferguson. The court sided with Ferguson, upholding the lower court's ruling. In response, Plessy appealed the case to the United States Supreme Court, and oral arguments were heard on April 13, 1896. The court announced their decision on May 18th, just a month later, that they had sided with Ferguson 7-1. Associate Justice Henry Billings Brown wrote the majority opinion, where the infamous, quote, separate but equal, end quote, doctrine was conceived. Brown claimed that the Separate Car Act did not violate the 13th or 14th Amendment because he deemed the segregated train cars to be of equal quality. Associate Justice John Marshall Harlan was the lone dissenter in this case, saying that the Constitution is colorblind and, quote, all citizens are equal before the law, end quote. Harlan correctly predicted that this Supreme Court decision would be considered one of the worst ever. Today, Plessy v. Ferguson lives in infamy, as the decision reaffirmed and strengthened Jim Crow laws in the South. However, Plessy was not the first time that the Supreme Court ruled in favor of segregation, as this decision in this case was heavily influenced by a precedent established from the next entry on this list. Number 3 case on this list, we have the civil rights cases of 1883. The civil rights cases were a combination of 5 cases that involved Black Americans who were denied entry into several white-owned businesses. In 1875, Congress passed a piece of civil rights legislation called the Enforcement Act. The law enforced that public accommodations, or businesses open to the public, must treat all people equally. The legislation also applied to privately owned businesses. However, some states did not enforce this law at all. The 5 plaintiffs in this case sued businesses individually in lower courts for refusing to serve them or allow them entry. 2 plaintiffs sued hotels, another 2 sued movie theaters, and the last one sued the Memphis and Charleston Railroad for denying them first-class accommodations. All 5 cases were appealed to the United States Supreme Court. Because the cases were so similar to one another, the Supreme Court decided to review all 5 and combine them into one. These cases later became known as simply the civil rights cases. The court heard oral arguments for this case on March 29, 1883. The big question justices faced was whether it was constitutional for Congress to regulate private companies in this manner. Also, the court argued whether the equal protection and due process clauses of the 14th Amendment extended to private businesses. If the 14th Amendment did not apply, then the 10th Amendment, which said that all powers not given to the federal government are given to the states, would apply in this case. On October 15, 1883, the court ruled in favor of the businesses. Associate Justice Joseph Bradley wrote the majority opinion, basically admitting that Black Americans were discriminated against, but the federal government did not have the authority over the states when it came to this matter, despite Bradley literally admitting that the plaintiffs' rights were being violated. The ruling deemed parts of the Enforcement Act unconstitutional. Pretty contradictory there, Bradley. Similarly to Plessy v. Ferguson, John Marshall Harlan was the lone dissenter in this case, and his opinion was extremely well written. Quote, "The one underlying purpose of congressional legislation has been to enable the black race to take the rank of mere citizens. The difficulty has been to compel a recognition of their legal right to take that rank and to secure the enjoyment of privileges belonging under the law to them as a component part of the people for whose welfare and happiness government is ordained." End quote. The civil rights case's decision would finally be overturned in 1964 with the passing of the Civil Rights Act of 1964 and the decision in Heart of Atlanta Motel v. United States. As previously mentioned, the Plessy v. Ferguson decision strengthened and reaffirmed segregation laws. The civil rights cases essentially made segregation legal, leaving Black Americans vulnerable to extreme discrimination for the next 81 years. Speaking of unjust discrimination, number 4, we have Korematsu v. United States. The story of this case began on December 7, 1941, in Pearl Harbor, Hawaii. This was one of the most tragic days in American history, as Japan bombed a U.S. naval base in Pearl Harbor. The attack killed more than 2,400 people and left thousands more injured. The United States declared war on Japan just 4 days after the bombing. American citizens became increasingly paranoid after Pearl Harbor, and racism against Japanese Americans reached colossal heights. Citizens accused Japanese Americans of colluding with or being spies for the Japanese government, despite there being no evidence whatsoever to support these claims. President Franklin Delano Roosevelt agreed with the false accusations and signed Executive Order 9066 on February 19, 1942. The order forced over 120,000 Japanese Americans from their homes into concentration camps, or as the United States government liked to call them, quote, relocation centers. The order specifically targeted Japanese Americans that lived on the West Coast. In fact, Japanese Americans weren't even allowed to live in states like California, Arizona, Oregon, and Washington unless they were in a camp. Fred Korematsu, a Japanese American, refused to comply with the order. Korematsu was a welder who lived in California with his girlfriend, who was not Japanese American. Korematsu went to great lengths to keep himself from being forced into an internment camp. He changed its name, he obtained a fake ID, and he even asked a doctor to perform plastic surgery on him. The doctor refused, but took Korematsu's money anyway. That's cruel. Korematsu successfully avoided detainment for 27 days before he was arrested and convicted in federal court, being sentenced to 5 years of probation while being relocated to the Utah Topaz internment camp. Korematsu appealed his conviction to the U.S. Court of Appeals for the Ninth Circuit, arguing that Executive Order 9066 violated the Due Process Clause of the Fifth Amendment, which it did. However, the appellate court disagreed and upheld the ruling of the lower court. Korematsu then appealed this case to the Supreme Court, and oral arguments for the case were heard on October 11, 1944, in what became known as Korematsu v. United States. The court announced on December 18, 1944, that they had sided with the United States in a 6-3 decision. Justice Hugo Black wrote the majority opinion for this case, saying that he was not detained because of his race, but rather to protect citizens from espionage, wrongfully claiming that Japanese Americans were domestically colluding against the United States. Justice Felix Frankfurter also wrote a concurring opinion, a wrong one, saying that the president had the right to imprison people during wartime. The three dissenting justices all furiously wrote opinions. None of them were more furious, however, than Frank Murphy, who said that the decision essentially legalized racism and that all Americans, regardless of race, are entitled to the rights given to them by the Constitution. Japanese internment is not a topic you learn about in your high school's American history class. The enforcement of Executive Order 9066 marked one of the darkest chapters in American history, where citizens were stripped of their rights based on nothing more than unwarranted paranoia. Thankfully, President Roosevelt had enough sense to cancel his order on January 2nd, 1945. Unfortunately, however, when Japanese Americans left these camps to return to their homes, they found their properties vandalized and looted. The Korematsu's decision was officially overturned in 2018 by the Supreme Court decision in Trump v. Hawaii. For the fifth and final entry of this list, we're going to talk about Buck v. Bell. And this one is just sad. The story of Buck v. Bell started in Madison Heights, Virginia on September 10th, 1924. Carrie Buck, the plaintiff in this case, had a horrific childhood. Her mother was taken away from her family and was admitted to a mental institution because the state declared her, quote, feeble-minded. Consequently, this forced Buck to be raised by foster parents who just treated her horribly. When Buck was 13, she was raped by her foster mother's nephew, resulting in her getting pregnant. However, the state deemed Buck to be mentally unfit to take care of her child, and her child, Vivian, was taken away from her and adopted by her horrible foster parents. Vivian was also declared to be, quote, feeble-minded at just 7 months old. When Buck turned 18, she was admitted to a mental institution. A doctor named Albert Sidney Priddy wanted to sterilize Buck because, according to Priddy, she had the, quote, mental age, end quote, of a 9-year-old. Priddy was a strong supporter of eugenics, which is a study that uses selective breeding among humans to increase the occurrence of hereditary traits that were seen as, quote, desirable. Priddy wanted to do the procedure on Buck, but wanted to make sure that it would be legal. Although the state had passed a law called the Virginia Sterilization Act of 1924, which made eugenics procedures legal, the law had not yet been tested in court. People at the Virginia State Colony for Epileptics and Feeble-Minded put together a plan where they appointed an employee named Robert Shelton to be Buck's guardian. Shelton's lawyer was named Irving Whitehead and would represent Buck in court. However, Whitehead was actually a huge proponent of eugenics and was friends with Priddy and his attorney. So you can see where this is going. Whitehead, quote, argued for Buck in the Virginia Circuit Court, but the court, of course, sided with the mental health clinic. Although the lower court ruled in favor of the Virginia law, Shelton wanted to appeal this case all the way to the United States Supreme Court. That way, the clinic would have free rein to do eugenics procedures without any legal repercussions. Shelton and Whitehead first appealed the case to the Virginia Supreme Court, which upheld the lower court's ruling. It is also worth mentioning that throughout these hearings, Whitehead never challenged the false accusations that Buck was, quote, feeble-minded. The case was finally appealed to the Supreme Court, and oral arguments were heard on April 22, 1927. Priddy had died before this case was heard by the Supreme Court, so a new doctor named John Bell represented the clinic instead. On May 2, 1972, the court announced that they had sided with Bell in an 8-1 decision. Associate Justice Oliver Wendell Holmes wrote the majority opinion, saying that the Equal Protection Clause of the 14th Amendment was void in this situation, since Buck was in a mental institution, arguing that the clause only applies for the public at large. Holmes said that in order for society to not be, quote, swamped with incompetence, end quote, sterilizations must take place. For further opinion, here's what he said, quote, it is better for all the world if instead of waiting to execute degenerate offspring for crime, or to let them starve for their imbecility, society can prevent those who are manifestly unfit from continuing their kind, Holmes said. Holmes also concluded his arguments by saying that since Buck's mother and daughter were deemed to be, quote, feeble-minded, that, quote, 3 generations of imbeciles are enough. The lone dissenter, Pierce Butler, failed to write an opinion. On October 19, 1972, Bell performed the forced sterilization on Carrie Buck, ensuring that she could never reproduce. Carrie's sister Doris was sterilized without her knowledge after she was hospitalized for appendicitis. Doris and her husband attempted to have children for several years, but were unsuccessful. No doctor ever told Doris about the sterilization until 1980. Carrie's daughter, Vivian, who is also deemed, quote, feeble-minded, did well in school, but tragically died at just 8 years old. There was no evidence that Carrie, her sister, or her daughter were ever feeble-minded at all, and the accusations were solely based on Carrie and Doris's mother. People who knew Carrie said she was extremely friendly and of average intelligence. Carrie died on January 28, 1983, and was buried in Charlottesville, Virginia, next to her only daughter, Vivian. Buck v. Bell had a lasting impact on not just the United States, but the entire world. Around 70,000 Americans were forcibly sterilized after this ruling without being informed about it. At one time, 30 states had separate sterilization laws. After World War II, Nazi doctors testified against themselves at the Nuremberg trials. In order to defend themselves, the Nazi doctors used Holmes' opinion and Buck v. Bell as one of their defenses. The events of what Germany did in World War II pretty much ended the eugenics movement in the United States, but the damage was done for 70,000 people. The decision in Buck v. Bell has never officially been overturned, shockingly, although it was weakened in 1942 by the decision in Skinner v. Oklahoma, when the court ruled that mental health patients were, in fact, protected under the 14th Amendment. So this was a tough video to make, but I want to thank you for watching. Even the darkest parts of our history, I think, are very important to know about. If you like this video, please give it a thumbs up and make sure to subscribe to this channel. We'll be putting out more content. Maybe we'll look at the 5 best Supreme Court decisions, to put a more positive spin on things after this video. Also want to upload more history content as I'm really into it right now. So again, thank you so much for watching.